probate costs money. Like I mentioned in the intro, I charge more for a probate case than I do for a estate plan that avoids probate in almost every case. Okay. Probate involves court fees, lawyer fees, like I just mentioned. Sometimes you have to pay appraisers to come do appraisals. Sometimes you have to pay the executor to act. Executors are able to take a fee, and so that eats into the beneficiary's inheritance. And so all these fees put together reduce the amount that's going to your family and your friends and your beneficiaries, the charitable organizations that you might support. So money is a factor, right? Especially if you can do it for cheaper during your lifetime, maybe get that money back during the rest of your lifetime.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning can often be a confusing and complicated topic, but my goal with this podcast is to make it accessible and understandable to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic as always. Today's topic is the probate conundrum, 10 reasons to avoid probate. Because avoiding probate can greatly simplify the estate administration process after someone passes away. So on today's show, we're talking about the probate conundrum, 10 reasons to avoid probate. So let's get to it. Probate. We've all heard the word probate, right? You've all had friends or family talk to you or mention probate, right? And sometimes it's considered a dirty word around guys like me who are estate planning attorneys. And as a process, it typically gets a bad rap. So if you're interested in learning about reasons that probate might be a good thing, you've come to the wrong episode of Legacy Talk, okay? Because today we're focusing on the bad, the dirty, the negatives of probate. There's a reason probate gets a bad reputation, okay? And on today's episode, we'll be exposing these reasons, at least 10 of them. So, as most of you know, I'm an estate planning attorney, but I also do probate because not everybody's estate is designed to not go through probate. And if it were up to me, while I have a very robust probate practice in addition to my estate planning practice, I wouldn't have to have another estate go through probate if it were up to me, okay? Even though most of these probate cases generate even more revenue for my firm than an estate planning case, in most cases, my loss could be your gain. So if you're interested in finding out 10 reasons to avoid probate, you've come to the right place. By the way, if you want to find out good reasons to go through probate, you'll have to check out episode 4 of the podcast, where I went through whatever those reasons were. I think there were about 10 reasons that probate's not so bad. But today it's the bad, right? Today it's the dirty. It is the negatives of probate. 10 reasons to avoid probate. In this main section, let's talk about what probate is. So if you're listening to this podcast, you're thinking about estate planning or you're thinking about probate, and you're probably wondering, why is he talking about avoiding probate? He's a lawyer that practices in probate. So let's start with what probate is, right? And so probate is basically the legal process to get somebody appointed as an executor or an administrator of an estate. when someone passes away. And the reason that person has to get appointed is because we have to transfer title. And so probate is a title transfer process. That means when someone dies, they're no longer able to sign their name on documents transferring title, like documents on a deed for a house or a bank account or a brokerage account or car titles, things like that. When someone dies, they can't sign anymore, right? So probate is the process to get someone appointed to sign on behalf of someone that is deceased. And in order to do that, that person has to go to court, has to appear before a judge and petition the court to be appointed as an administrator or executor of an estate. And so that's the gist of the probate, mechanically, right? You go to court, you petition the court, you get appointed. And then the court says, let us know every once in a while what's going on. In some cases, they say, let us know every time you do something. And in some cases, they say, well, we'd like to have you post a bond with that estate. Okay? And so it's not the easiest thing in the world. It's not the most fun thing in the world. It's not something that most people want to do with their time. And so, hence today's episode, The Probate Conundrum, 10 reasons to avoid probate, starting now. Number 1, speaking of time, it's a time-consuming process. Probates take several months to administer, okay? Minimum time typically in Washington State is 4 months. And that's because the creditors have a 4-month window to make claims. And most people that file probates file a notice to creditors and publish it in the newspaper and tell creditors, hey, you have 4 months to make a claim, particularly if we don't know you. And if you don't, you're out, okay? And so you're at least in the thing for 4 months. Most probates that I run, we try to get them done within 6 to 12 months, ideally. But many of them last for years. I've got probates that have been open for 5+ years, and they're still going. And so not every probate's the same, of course, but they do take time. It's like a part-time job, and in certain cases it can be like a full-time job. And most people that are acting as executors, if you want to learn about picking your executor, there's another episode in this podcast series about picking an executor or trustee. Those people usually have jobs too, right? They usually have a career, and they're busy as well. So it's hard to make the time for that. So a lot of the things have to be done in piecemeal, overtime, on weekends, at night. So it's basically becoming this part-time job. And during this time, you're waiting, typically we're not making full distribution of the estate. So beneficiaries are waiting too. They're having to wait for their beneficial interest in this estate to be distributed. They're waiting for houses to sell. They're waiting for taxes to be paid. They're waiting for bills to be paid, creditors. And so that's going to be another time. So it's a time suck for the executor, and it's also a timely process, I guess, for the beneficiaries of the estate. Number 2, probate costs money. Like I mentioned in the intro, I charge more for a probate case than I do for a estate plan that avoids probate in almost every case. Okay? Probate involves court fees, lawyer fees, like I just mentioned. Sometimes you have to pay appraisers to come do appraisals. Sometimes you have to pay the executor to act. Executors are able to take a fee, and so that eats into the beneficiary's inheritance. And so all these fees put together reduce the amount that's going to your family and your friends and your beneficiaries, the charitable organizations that you might support. So money is a factor, right? Especially if you can do it for cheaper during your lifetime, maybe get that money back during the rest of your lifetime. Number 3, lack of privacy. Probate is a public proceeding. Like any court case, probates are public. And so when anybody wants to know what good old Johnny had in the bank, or how much his house was worth, or did he have any other property, or what other investments did he have, most of these probates have an inventory that's filed with the court, and that's all public record. And who's in charge is public record. And what the will says is public record. Okay. And so you're having the nosy neighbor come over, and we've talked about this before, but they're coming over and they're taking a look and spreading gossip a lot of the time. And so it's an invasion of privacy potentially, and it can lead to potential exploitation. It can lead to people trying to steal a deceased person's identity. These things have all happened. And so keeping the estate administration private and not public is usually a good idea. Number 4 reason to avoid probate, the potential for family disputes. So because probate is a court case filed with the court that's available for someone to file a grievance in or a contest or something, right? The people that are beneficiaries that might have a problem have a ready-made venue to assert their problems to an executor regarding an estate, okay? And because everything's public, that can heighten the tensions that are already there, oftentimes with the family. And I always tell my clients, if there's already a case open and someone's going to have a problem with this estate, guess who they've got a direct access to make their complaint? It's the judge, right? And so they've already got a court case to file things in. And because there's a court case, they think, the judge is going to do this and this, and I don't like this person acting in probate, and I want them removed, and they're doing the wrong thing. And if these things are true, right, if someone is doing the wrong things, they should be removed. They should be held accountable by the court. But if you're not, and you have a disgruntled beneficiary, having a court case open for people to basically try to get you out because they feel sad for some unknown reason that's not a valid reason to get someone removed, you don't want it to be there, okay? You want to squash that kind of stuff. And so because it's public, it sort of, and it's with the court, sort of gives someone an access point that otherwise isn't there, okay? Number 5, back to the courts. Court supervision can limit the executor's flexibility in managing the estate. So there's certain timelines that you have to follow as an executor of a probate estate. And these are guidelines that are determined by the court. And some cases require the court to have full intervention in the estate. So oftentimes if someone dies without a will, a court could impose full intervention powers on the estate, which means every little thing that an executor wants to do, like transfer an asset, have a garage sale, estate sale, sell a house, deal with banks, things like that, has to get a court order to approve it. So that's a fiasco. That can be a really high amount of money that would be required to run it. And it's a lot more time, and it's a lot more hassle, a lot more hoops to jump through. And while you're in probate, you have to report once in a while what's going on. And so you have to file an inventory, and you have to file an accounting, and you have to tell them when you're doing major things typically, and when you're done, and what your fees were, and all that kind of thing. So having the court there can set some restraints that make the process of administering someone's estate much more difficult. Number 6, frozen assets. And this is something that people don't think about. But oftentimes in probate, the first thing, actually, I'll back up. The first thing that happens typically when someone dies, and when you call the bank and say, Johnny died, they freeze the account, right? They don't want anything going in or out of this account because they don't want people trying to steal the money, which is good, and banks should do that. But until the probate is open, the executor has no ability to get to that account, okay? And oftentimes, if there's this full intervention powers, that executor can't do anything with that money without court order authorizing them to do it. And so immediate access is not there. Whereas on other forms of estate planning, like using revocable trust, which this is not about using a revocable trust as the administration tool, allows an executor to have, or a trustee, to have immediate access essentially to an account as a successor trustee if that account's in the trust. And like we talked about before, if these accounts are frozen and there may be beneficiaries that could use some money, they're not going to get that money right away at least. And so frozen assets, having delays with regard to assets is another reason to avoid probate. Number 7, we've talked about this before. Number 7, out-of-state property. So when you have property in multiple states, and we talk about this a lot as a reason to do a revocable trust, if you have a house here and a house in Arizona or a house in Idaho or California or wherever, if you have houses in multiple states, typically it's required that you open probate in each one of those states. So if you have a house in Idaho that you go to in the summers or whatever, or in Arizona if you're snowbirds or whatever, if you have a house there, the probate court in Arizona or Idaho has to deal with the title of that house. Whereas if you're in Washington, the Washington probate court has to deal with the title of this state's house, okay? And so if you have multiple properties and you don't have a trust, you're going to have multiple probates. So it makes sense to avoid probate if you have properties, particularly in multiple states, because you're avoiding multiple probates, okay? Number 8, complexity. So probate involves navigating legal requirements, filing legal paperwork with the court. It's usually something that executors or people that are asked to be executors are unfamiliar with, and is, like we talked about before, overwhelming and oftentimes consuming. This can be alleviated somewhat by hiring an attorney, right? So if you have a probate problem, I'm a probate attorney, so I'm happy to help people with probate problems. But just because you hire an attorney, usually, like when I'm representing probate clients, we don't do the legwork, right? The lawyer can't do the legwork because the lawyer's not executor, right? The lawyer's not appointed by the court to act. Our job is to do the legal paperwork, to give advice, to go to court on behalf of the executor, things like that. But we can't go to the banks and say, hey, the executor's appointed now, give him money, right? And we can't go sign documents at the title company for a sale of a house, right? We can't do those things because we're not the executor. We can advise. So even if you hire an attorney for probate, that executor is going to do a lot of legwork. They're going to do a lot of walking around, driving around to various banks and institutions. They're going to be on the phone a lot. And so the complexity of the whole thing requires an attorney in most cases, and it makes it so that executor should have to take a lot of time off. Sometimes they have to learn a lot of things they don't want to have to learn. And so complexity is a reason to get rid of the thing or avoid it altogether. Number 9, executor liability. So when Johnny died and he made Bobby his executor, Bobby's his good old friend, Bob, doesn't always realize that he might have personal liability for acts that he does in the estate that are wrong, right? They can be personally liable if they don't correctly manage the estate. Executors have a fiduciary duty to the beneficiaries of the estate to run the estate, to manage it for the best interest, in the best interest of the beneficiary. And if they don't, they're at risk of facing legal action for not acting in everyone's best interest. And so the executor could face personal liability. And I guess I should back up on this. So if you're in court, you have a ready-made venue to get after this executor. Not to say you shouldn't always act properly, and you should. And executors and trustees always should follow the rules of the law and deal with the trust as written, okay? But being in court amplifies that responsibility because there's a judge looking over your shoulder, and the beneficiaries know, well, we're going to get him in court if he does anything wrong, okay? So executor liability is a problem. And that's sometimes the reason the courts require the executor to post a bond, which is basically like a life insurance or insurance policy that covers the executor if there's a problem, is because they don't want this liability to be an issue, okay? So that executor liability can be a problem cost-wise and for the executor. Finally, number 10 reason to avoid probate is inheritance delays. And we mentioned this a little bit at the top of this list, but oftentimes probate requires court approval. It always requires court approval to close. Oftentimes it requires court approval for different intermittent distributions, and so it can cause delays for the beneficiaries. And these delays sometimes can cause financial hardships, which we talked about. These delays can all be avoided when using a revocable trust in lieu of a will for your estate plan. Almost all of them. Okay. And so avoid probate. Okay. So I thought, like, when I did the episode on what's so great about probate, I mentioned a couple of these. Why do we want to avoid that thing? And so I thought I'd do the opposite on this one too. So I've got a few reasons to do probate. One is the same reason we want to avoid it. The other one is why we want to go through it, which is court oversight and protection. Probate in courts ensures typically that the estate is managed and distributed according to law. Okay. There's court oversight to make sure that the beneficiaries are protected and the executor is acting properly and fulfilling their fiduciary duty. So court oversight can be a positive. Number 2 positive thing about probate is that debts and creditor claims can be dealt with somewhat easily. In a probate, there's a venue there. There's a procedure for dealing with creditors. We talked about this notice period, which is 4 months for unknown creditors. And after that 4 months, they're out, right? They're out. And so it provides for the even distribution and formal process of notifying and dealing with creditors. And so that's a potential positive. If there's a lot of debts, probate sometimes might be a better idea. Number 3, validation of the will. So will authentication is a thing. Probate involves the legal authentication of the will by the court. So the will is accepted and validated by the court when you open a probate. If you don't have a will, though, you're still going through probate. And if you have a revocable trust, you don't need that will, unless there's an asset not in the trust when you die and you have a pour-over will, which is another topic. But that validation of the will can prevent fraud. Not in every case, because I'll give you an example of this in the example section of this. Number 4, clarification and resolution of disputes. Probate often provides a forum for resolving unclear and contested issues, and the courts involvement can settle disputes and provide a binding resolution at the end. So if there are problems and there are mad beneficiaries, sometimes it is a good idea to get in a probate so that everything's on the table. And number 5, if you don't have the kind of assets that would require a probate, things like real property and things with title, bank accounts, investment accounts, or if they're very low in value other than having real property, you can go through a simplified process to avoid probate with an affidavit process. So there is a simplified process in Washington. If it's under $100,000, you can usually get rid of the probate process, but it can't involve real estate and other things sometimes. And that can reduce costs and issues and all that stuff. So, all right. Which brings us to our story time. So I've got a couple stories this time. I'm going to tell you about that first one first, the will validation thing. Okay. This is a pretty bad story. Dad was an older man. He was taken advantage of by a couple who went and had a will drafted. The will's not fake, and it was drafted by a reputable law firm, but this will cut out the man's 2 kids and appointed this couple as executor and beneficiaries of the estate. The will, and this is interesting, okay? The will was admitted to probate by this executor person. This will was not executed in the most traditional way. There were blank pages, there were blank signatures, spaces, and the witnesses signed this will on a different day than the decedent signed the will, the dead person. And the notary notarized the witnesses after the guy's, it was like a month or 2 after. And I think it was on the day he died. But he signed it a couple months before that. And so these witnesses, or purported witnesses, signed this paper, and they were apparently there was a notary there. That's what the executor petitioner thought or mentioned or proposed. Turns out one of the witnesses never saw the executor sign the thing, and there was no notary when he signed. He never saw a notary. And so the will that was admitted to court was admitted as a valid will. It's really weird, but we have witness testimony that it wasn't. Okay, so this probate is going through a process where this other couple was sort of trying to run things and take this estate, but the son was trying to invalidate that will and get rid of it. So even if there's a will, and even if there's a probate court involved, you can get a bad will through. And if it weren't for this son, everything would have basically gone to these people. But thankfully, he figured this out, and it's going in his favor. So probate is not always the arbiter of, is this will great? Because this thing was a piece of garbage, in my opinion. So at least execution-wise. And so that's not always a fail-safe, that validation of the will. So going through probate isn't always a fail-safe. Another case that I was involved in had a proposed will, purported will, and it turned out that was forged. And so the lawyers that were saying, hey, we found this will, and I was representing the deceased person's wife for many years, and we saw the will, and she's like, that's not my husband's signature. And the other attorney was basically backed off, and they said, well, yeah, looks like you're right. And we showed him the driver's license and the social security card and some other stuff that he had signed over the years, and it was not the signature. Turns out the son was trying to pull something off. And so probate in that situation would have been a disaster if it weren't for third-party, thoughts on this will. And so it's not always the perfect situation to get into. And third story I guess I'll give you is a surviving spouse and intestate estate. So there was no will. There's a daughter from a previous marriage, which means when there's separate property, typically, and there's separate kids, the surviving spouse gets half of the separate property and the other kids get half of the separate property. In this case, there's a piece of real estate that's being rented. The daughter that's involved is keeping all of the rents, and the property is inhabited by tenants who are not wanting to leave, and it's just a fiasco. So, and there's issues as far as having to do it all at all. And the reason it's even going through probate and even being distributed like this is because the guy didn't have a will, but it's going to be a long slog. It's a long slog. That kind of a case is always a long slog. And so my advice, if I'm giving advice unsolicited, and this is not binding, it doesn't treat a client relationship, is if you can avoid probate, do it, right? Avoid probate if you can. Because why would you go through that? Why would you let a third party get involved in typically a family matter? And so if you do the proper estate planning, if you do, instead of a will-based plan, do a revocable trust-based plan, in almost every situation, you will avoid having to go through probate. And you'll avoid having to go through court. You'll avoid having to hire additional attorneys that are going to charge you fees, and it's going to take you extra time and extra money to administer if you could have just done it cheaper at the front end and easier at the front end. And then there's a weird thing. Like this week, we had a meeting with some clients, I think, and one of my consultants had a meeting with some clients, and they were thinking, well, do I do a will or a trust? And they were thinking back and forth, and they came back and said, well, we read about probate, and we think it's not too bad, and so we're going to go with the will. So I'm not sure what this couple may have read. There's other things out there that say probate's not the worst thing in the world. But if it were up to me, and if you're looking for my opinion on this topic, avoid probate if possible. Okay. And that leads us to our Something Good segment, which we have again this week. And we're in graduation season. And so I saw an article that I thought would be interesting during this time of year. The status of high school valedictorian is often an honor that many parents would be thrilled that their kid received, right? But what if all of your kids successfully became valedictorian? A Central Florida family may have made history after all 4 daughters were named valedictorian in their respective high school classes, a feat that's reportedly 1 in 11 billion chance, so almost impossible statistically. 1 in 11 billion. 1 in a billion is hard enough. 1 in 11 billion? Tracy Rendina's 4 girls, Riley, Taylor, Alyssa, and McKaylee, all graduated from the same high school in different years, and each one of them took home the coveted academic award. Rendina said that she and her husband Mike never put any pressure on her daughters to achieve this goal. We never told them they had to make A's. There was no telling them you have to do this or else. It was always do your best. As long as you're doing your best, whatever it is, what we expect, she said. And they also mentioned that they support their kids in success and failure, which is good for all parents to do. And the one other thing that they talked about in that article is once the third one made valedictorian, the fourth one was like, oh, I've got to do it now. And the relief that she felt when she got it was, significant. So I thought that was a good story, something good. We're thinking about graduating. We see all these pictures of seniors all over our house, and it's a great time to celebrate them this time of year. And that's it. That's the end of this episode. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.